Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. And the content that we're going to talk about today is breaking as of yesterday. There is a new case that has been petitioned to the Supreme Court, which could basically rearm nonviolent felons, and the case that is being presented pretty much cannot be a more perfect example of a person turning their life around. This is something that is SCOTUS bound, and if there was ever a case to choose, this would be it. I can't wait to share with you guys. Let me know what you think in the comments below, and of course, everything is linked per usual, and make sure that you hit that like button, subscribe to the channel, and turn the notification bell on. And with that, let's dive right in here. We have got to talk about this because this one, I want to know your opinions on this. You guys can tell me if you think nonviolent felons should or should not have gun rights, and also if you think this is the ideal case to take if they're going to do it. Check this out. This is an interesting one, and even Amy Coney Barrett has history and precedent of addressing this issue, which it gets interesting. Check this out. She lost her gun rights for passing a bad check. Now she wants the Supreme Court to restore them. Now this came out December 29th, so this is as of today, and the filing was yesterday. A Utah woman convicted of a felony for trying to cash a fake check in 2008 has taken her fight to own a gun to the Supreme Court. Her attorneys filed a petition for review with the High Court last week on this question, whether the Second Amendment allows the federal government to permanently disarm petitioner Melinda Vincent, who has one 15-year-old nonviolent felony conviction for trying to cash a bad check. And that's kind of where we're at. You guys are well aware that felons cannot have guns in their possession. Well, if it's a nonviolent felon or it's a violent felon, this is arguing they're two different things. Now, I'm going to walk you through the case here, and it's actually very interesting, and I'm curious to hear your guys' thoughts on this one. But if there was ever, like I said, a case that was perfect to go to the SCOTUS for this, this would be it. This is kind of like the inverse of the Rahimi case, where the guy was clearly not a great person to stand in front of the Supreme Court, but this is the opposite. This is a pretty solid person to stand in front of the Supreme Court. Check this out. The details are interesting. Vincent, a single mother who has 2 advanced degrees, who works as a licensed clinical social worker, so improves the community, 2 advanced degrees, and is a single mother, okay, that's 3 things, wants to buy a gun to protect herself and go hunting and target shooting with her family. But the conviction for attempting to cash a fraudulent $498.12 check at a Salt Lake grocery store prohibits her from ever possessing a firearm. Should bouncing a $498 check prohibit you from owning a firearm? That's the question. Especially if you've got 2 advanced degrees, you're a single mother, and you are a social worker. I mean, that does present a pretty interesting question. It's not like you're out there beating people's faces in. Anyway, let's continue. Vincent is the founder and executive director of the Utah Harm Reduction Coalition, a nonprofit that works to develop science-driven drug and criminal justice reform policies. She also started the first legal syringe exchange service in the state. This is not a bad person compared to what they've done in the past 15 years. So that begs the question. If it's nonviolent, you've turned your life around, should the state be able to take your gun rights away forever for bouncing a $500 check? That's a very valid question. Again, there is a difference. Everything is not black and white. There are shades of gray occasionally. If you're going to put something in front of the SCOTUS, this would be it. Again, depending on your opinion on this, and you guys can let me know. But listen to what the actual argument is, because Bruin is coming a knocking, and this is actually interesting application. Check this out, because this, legitimately could be a very big deal. A federal judge in Salt Lake City dismissed Vincent's lawsuit in 2021, reasoning the laws prohibited felons from possessing a firearm are presumptively valid. The 10th Circuit Court of Appeals affirmed the dismissal, which is how it gets to the SCOTUS appeal, okay? Vincent's attorneys, it doesn't matter who they are, argue in the Supreme Court petition that the 10th Circuit's decision violate her Second Amendment rights because historical tradition of firearms regulation does not permit the federal government from disarming someone solely based on a non-violent felony conviction. Now, this is the important piece. Again, this distinction is non-violent versus violent. And I think it's an interesting argument to be made. This person is an ideal candidate for a case to go before the SCOTUS around this entire area. Now, I understand it's a touchy subject, but if you're going to do it, this would be the one to do it. Now, this last piece of this argument, this is interesting. I'm going to bounce to the end real quick to address the nonviolent part with Bruin. Quote, we're saying that there is a historical tradition to disarm violent offenders. So that's the lawyer. They believe there is a historical tradition to disarm violent offenders. People who threaten public safety, but not the whole litany of felonies like Miss Vincent's financial offense. Basically, they're arguing and saying there is precedent for those that are violent, but there is no precedent, according to Bruin, for the historical text and tradition, of nonviolent, like financial crimes. That is a legitimate argument. I would be curious to hear what the SCOTUS would say. But anyway, let's get in here real quick. Mazzani, who is one of the lawyers, said there's no historical basis for the 1961 law adding a modern felony can be anything new. Quote, it's our position, and we've shown that nonviolent felons have never been deprived of firearms until 1961, he said. This case, he said, is not attempting to upset felon in possession laws. Now, the reason that I show you that part is because the left, the gun controllers, mom demand action, all of it, every town, they're going to line up and say the gun control advocate or the gun rights advocates want felons to have guns. Specifically said, not going for violent offenders, non-violent offenders. That's an important distinction here. But I'm really curious what you guys think on this. And I got one more thing, because this is where Amy Coney Barrett comes in, and it gets interesting because she has history with this exact same subject, especially since she's one of the justices now who's kind of wishy-washy sometimes. All right, let's get it. In a dissenting opinion in a Seventh Circuit Court of Appeals case before she joined the High Court, Barrett concluded that only people convicted of dangerous felonies should lose their rights to keep and bear arms. She traced the history of the Second Amendment and the punishing of convicted felons to colonial times. History, she wrote, is consistent with common sense that legislatures have the power to prohibit dangerous people from possessing guns, but that power extends only to people who are dangerous. So it sounds kind of like she's on the fence of nonviolent felons should have their gun rights, but violent felons should not. That's what it sounds like. I can't interpret it. You guys can tell me. And then this last thing, quote, in some, founding-era legislatures categorically disarmed groups whom they judged to be a threat to the public safety, Barrett wrote. But neither the convention proposals nor historical practice supports a legislative power to categorically disarm felons because of their status as felons. And that's the entire point. It's not that they are a felon, it's that they are either a subcategory, a violent felon or a non-violent felon. In this case, again, drawing an example to the Rahimi case. The Rahimi case, the guy was a terrible person before the Supreme Court because he was an active criminal. He was obviously not a good person. It was pretty hard to defend that position. That's why the gun controllers went ham sandwich on the whole domestic violence abusers should have guns, should not have guns, and they made hay on it. This one is a person who did a $500 check 15 years ago and has since completed 2 advanced degrees, is a social worker, runs a nonprofit to help people, and is a single mother. That's going to be a little bit harder to assail from the gun control position. Meanwhile, there's actually basis in history, text, and tradition through the Bruin decision, and one of the sitting justices has a history of supporting that exact same point. This is an interesting one. Let me know what you guys think in the comments below. Do you think they're going to accept it? Do you think we're going to see this again, or is this just more noise? Let me know what you think, and I will see you on the next one. I'm Braden. See you later.